had some questions about some pending motions that need to be resolved prior to sentencing. There is a motion for a new trial that has been filed by the defense, and the state has obviously resisted that motion. And I'm to understand that while there are a number of things that I actually think could be resolved about the motion today, I believe the defense wants some more time to explore one aspect of the motion. So Ms. Garner, Ms. Tucker wants to talk about that.
Your Honor, at this time we would be asking for a motion for a new trial. As the court notes in State v. Ellis, ELLIS 578 Northwest 2nd, 665, 659, Iowa Supreme Court case 1998, a district court should grant a motion for a new trial only in exceptional circumstances. In this case, Your Honor, we believe that the exceptional circumstance is that we were given, on or about April 17th, 2024, a new police report listing a new witness and 2 other potential witnesses. As the court notes that when looking at whether or not a new trial should be given based on newly discovered evidence, it looks at whether or not the evidence was, the prosecution suppressed the evidence, whether or not the evidence was favorable or material to the issue of guilt. In this case, Your Honor, we don't even get to don't get to the question of being able to answer whether or not the evidence was material. And as the court notes, material is when there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceedings would have been different. In this case, the argument is in regards to whether or not justification was used. Because we have not been given enough time to be able to interview this witness who was, based on the police report, it appears on top of the scene or the incident, who would have seen things more clearly. We don't know what she saw in regards to whether or not that would be favorable for Mr. Walker. So at this point, we can't fully develop our argument for whether or not this matter is material and favorable, and therefore a new trial should be granted. And because of that, we would ask for a continuance to allow for the defense to do so.
All right. And then, yes, we'll have from the state.
Your Honor, the state would resist the defense motion at this time for a new trial. The state did brief the court, specifically the defense in their motion. Didn't quite say it, but they alluded to the fact of potential Brady violations, essentially, in their motion. The state laid out the test for Brady. Quite frankly, the defense doesn't even get past the first prong of the prosecution to suppress the evidence. This evidence came after trial. The evidence was provided the same day the state received the evidence, April 17th. It was sent the same day to defense counsel. The state also walked through the other elements as well. It has to be favorable to the defendant. That was even provided as an exhibit by the defense counsel. The statements of this other witness stated the police definitely got the right person, and she was 100% positive the defendant was the shooter. This would have benefited the state, would not have been beneficial to the defendant, and then further was material to the issue of guilt. Obviously, it would have been material, identifying the shooter and saying he had Mr. Walker had been the one who had committed the act. However, this evidence would have been cumulative, especially with the other evidence presented by the state, especially the video evidence showing Mr. Walker shooting and killing Mr. Barnes that day, as well as the other lay witnesses the state presented who were in fact there at the time of the shooting, including Marcus Johnson and Elliot Browway. So for those reasons, Your Honor, the state would ask the court to deny both the defendant's motion for new trial on that aspect, as well as continuing sentencing.
Your Honor, may I respond?
Yes.
Your Honor, in this case, when you look at the police report, it appears that the Cedar Rapids Police Department was contacted by this witness, as it states, a long time ago. Although This is a Marion Police Department case. The Cedar Rapids Police Department did respond to cocktails and shooting, so they were very well aware that there was a crime that did take place in Marion. Therefore, they had the duty to turn this evidence over to Marion Police Department. Based on the fact that they did not turn that evidence over to the Marion Police Department, and the Marion Police Department did not interview this witness until March 19th. So the police report was done back in March, on March 19th. We didn't get this report until March 17th. So almost 30 days later. So again, we would be arguing a suppression of evidence. And then if we want to be much more clear about this person states that she was standing next to the ATM where this incident took place. Therefore, she would be able to see more clearly than the camera views whether or not Mr. Barnes was going towards Mr. Walker, which would go to our justification defense, and therefore we would ask for continuance. Thank you.
All right. So, what I've been provided for this afternoon, I guess let me just start with the issue as to whether or not has not been alleged that there's a Brady violation, but it sounds like that's what you're saying, so I'll address that first. I'm not convinced that there was any Brady violation in this case for the reasons stated in the state's resistance and on the record this afternoon. Secondly, while I do think that given the important nature of this case, it is important for everyone to be able to present a full and complete picture to me. And so, Ms. Tucker and Ms. Garner, you're saying that you need to do more investigation before you can make an argument about whether or not there is important material evidence that has not been revealed, and I'll give you the time to do that. I guess I'll leave it at that. I do think that if the evidence is consistent, I suppose I won't leave it at that. I do think if the evidence is consistent with what the state is saying about what this witness said, I'm not sure how that will be important material evidence in the defendant's favor if the statement is that this is 100% the person who did it. But if you haven't done the investigation yet, so I'll give you time to do the investigation. And if there is something other than that you find that is in the defendant's favor, then obviously you will file something that contains that, and then we'll revisit the issue. So, how much time are you asking for to do these interviews?
Your Honor, if we could have at least until June.
All right.